Good afternoon, and welcome to Music Biz Monday. My name is David Schwartz, and on behalf of the New Mexico Music Commission Foundation, thank you for joining us today as we discuss how to protect your music and get a better understanding of the roles that copyright, publishing, and performing rights organizations play in the careers of musicians and songwriters. First, we'd like to thank our sponsor for today, the Candyman Strings and Things, New Mexico's premier and largest full-line music store. Thank you for joining us to present Music Biz Mondays, you guys. You're the best. And we urge everyone to get their music supplies at the Candyman. For our panel today, we have 4 distinguished attorneys who are also professional musicians. Our moderator is Gary Storm, who will introduce the rest of our panel in just a minute or two. But first, let me say a little bit about Gary. Dr. Storm is a musician, writer, and a water law attorney. He has a PhD in English and a law degree. He plays viola and guitar and has formed and played in numerous rock bands, including most recently the West Studi Band. He also writes and records music for children. Additionally, Gary is a radio disc jockey. His radio career began in Albuquerque in 1973 as an all-night DJ on KUNM. Upon receiving a fellowship to State University of New York at Buffalo, he became a well-respected all-night disc jockey and radio station music director there. His show, titled Oil of Dog, was aired in Buffalo on public and commercial radio during the late 70s and early 80s. Gary now broadcasts Oil of Dog 7 times a week on public radio KSFR in Santa Fe and streaming on Canadian radio station LKCB. Gary is married to artist, gallerist, and retired Montessori teacher Linda Storm. You can read more about Gary at oilofdog.com. So let's get things started now. Gary, would you please introduce our panel?
Sure. Good evening, gents and ladymen, and I am accompanied by a distinguished panel of musicians and attorneys. Starting with Talia Kosh here in Santa Fe. Talia Kosh practices law in Santa Fe at the Bennett Law Group. She founded the New Mexico Lawyers for the Arts and works primarily with creatives, filmmakers, and nonprofits. Talia serves on the Governor's Council for Film and Media Industries in New Mexico, as well as the Intellectual Property section of the New Mexico Bar. Talia was an adjunct professor at Santa Fe Community College and frequently lectures on various topics about art and law. Talia is also a singer and a songwriter. Next, I will introduce Judge Roderick Kennedy. Judge Kennedy is an internationally known expert on DWI-related law and science and is a published author and lecturer on the subject. He has presented papers at the International Conference of Alcohol, Drugs, and Traffic Safety, at their meetings in Australia and in Seattle. He wrote about a third of the International Conference on Alcohol, Drugs, and Traffic Safety position paper on drugs and driving that was published in 2002. So for all of us who are interested in not only rock and roll, but the sex and drugs aspect of it, we have an expert here on our panel. Judge Kennedy is a fellow at the American Academy of Forensic Sciences, which has served in a number of capacities, including as a member of their ethics committee and board of directors. He's a professional member of the Chartered Society of Forensic Science in the UK, from which he received a J.B. Firth Medal in 2003. He's also been an associate member of the International Council on Alcohol, Drugs, and Traffic Safety. And in 2000, Judge Kennedy served as co-chair of the American Bar Association's Conference of State Trial Judges Ethics Committee and currently serves as the Science and Technology Section and vice chair of the Scientific Evidence Committee. Rod Kennedy has also been active in charities and service organizations in Albuquerque, serving as the director and officer of the New Mexico Zoological Society and Share Your Care, Inc., which is a daycare center for disabled adults and the elderly. And Rod Kennedy is also a guitarist. So thank you. Finally, I want to introduce our third panel member who is in Los Angeles. This is Michael Lee Jackson. Hey, Michael. Michael Lee Jackson is an entertainment and contract lawyer. A partner at Jackson & Jackson LLP, Michael's legal career started when famed civil rights attorney William M. Kunstler invited Michael to work in his office. Michael attended the State University of New York at Buffalo Law School and clerked summers in Kunstler's office. Michael Lee Jackson acquired further experience and knowledge working for law firms in Buffalo, New York, and for the last 20 or so years, Michael has practiced contract law with a concentration on electronic game publishing, music, film, and general business. Along the way, Jackson has accumulated considerable experience with respect to intellectual property and related licensing. As a musician, Michael has worked as creative manager, band leader, and guitar player for Ian Gillan from Deep Purple. He played lead guitar with 10,000 Maniacs internationally, and around 2003, Michael recorded with Greg Lake a collection of covers from Emerson, Lake and Palmer, King Crimson, and Greg's solo work. Jackson has also released numerous records with his group Animal Planet, as well as his solo projects, his most recent being an album called Satisfaction Garage with Michael Lee Jackson and the Gatos Malos, on which he collaborated with the famed tone guru and recently passed away producer Rick Blagona. And Michael Lee Jackson is also a noted photographer. He has exhibited his works in Los Angeles and Buffalo, New York, and published a photography book called Shadow in 2013, and is currently working on the release of another book of photography called Super Bloom, which should be out in October. So those are our panelists, and welcome aboard. And the topic is protecting music and the perplexing and sometimes arcane and not entirely intuitive process of making sure people don't steal our songs and making sure we get paid for the songs when they're used by people or when they're performed. And so Talia is going to talk, focus primarily on copywriting, and Michael's going to focus primarily on performance rights organizations, and Judge Kennedy is going to be here as our persona gravitas, and is also going to offer a judge's perspective on anything that we have to say. So Talia, do you want to begin by talking a bit about copywriting?
Sure. Yes, I was asked to kind of give a flash talk on Copyright 101. So I'm going to be sharing my screen now so you can follow along with some PowerPoints. And you can, you don't have to take vigorous notes because you can always request this, this PowerPoint after this presentation. I will make it available. Copyright 101 for musicians. This is kind of a disclaimer in a way that this is all very convoluted. Nothing is easy to understand about this, especially as it relates to music. But we'll do the best we can in the hour that we have. So what is a copyright? The shortest definition is an original work fixed in a tangible form of expression. So what does that mean? It has to have originality, which only requires a spark. So if you're writing a song or you're contributing to a song, there's enough originality there to have a copyright. And you need authorship, which means you need an artist to create the work. And you need it to be fixed. Just having something unwritten or performed publicly without any other sort of fixation, like a recording, would not be enough. It needs to have some sort of fixation to it. Also, I want to talk about this idea versus expression dichotomy, which is outlined in the Copyright Act. The expression of ideas when they're fixed in a tangible form in some way, but it doesn't protect ideas. No idea, procedure, process, system, concept, method of operation, principle, or discovery is eligible for copyright.
So Talia, if I can ask, so for example, if I write a song about E equals MC squared, my song is protected, but but Einstein is out of luck. Is that right?
Right, that's right. And similarly, the example I like to give is, like a movie theme: boy meets girl, boy gets girl. Like the typical romantic comedy theme. You can't copyright that idea. It's the expression of that idea that would be copyrightable. Or in the case of music, the arrangement. Copyright myth. Phil Moon wanted us to bring this up. I think it was the poor man's copyright. So mailing yourself a copy of your music, there's this myth that that's all you really need to do and that's good enough. And we'll talk about the different ways that you can protect your work, but you don't need to do that. And it doesn't register your work with the Copyright Office. And as soon as you have created your work, you have a copyright in it. So you don't actually need to mail yourself anything. The other issue that comes up, and gentlemen, jump in whenever you have something to add, is when you are collaborating with another writer. And we call those authors as well. So a joint work is a work prepared by two or more authors with the intention that the contributions are merged into an inseparable or interdependent parts of a whole. So you have to have that intention. So if you are working with a composer and a lyricist, obviously that intention is there to create this song together. And in the case of joint authors, they both have a right to non-exclusively use and license the work as they wish, subject to an accounting of profits to the other owner or authors. It's great that this has a statutory provision that we can go to, but really this is why you want to have some kind of collaboration agreement or an agreement that sets forth the share of profits, the share of rights and into the song, so that you're not working that out later down the road with your bandmates or whoever it is that you are working on your song with.
So we're talking, for example, like Elton John and Bernie Taupin. Is that was his lyricist, right? And so they surely must have some sort of agreement that they've worked out between the two of them as to who gets what.
I'm sure they do. Michael, you have something to say on this?
Yeah, I do. I inevitably our subjects are going to overlap a little bit, and I agree 100% with what you just said about encouraging artists to have some kind of agreement. I've written up a split sheet that I think will be available on the website after this show, but it's a really simple one-page document that I give away to people because I want everybody to sign it when they write a song. There'll never be an easier time than when you're sitting around the table together or in a room together playing to memorialize your understanding of who contributed what. It's very simple. I came up with the chorus. I think that's 50% or whatever. Just agree on it, write it down, sign it. I don't even care if it's on a bar napkin, but it is the best time to do this, and it will inform everything that happens with that copyright subsequently. It's much harder to do that and to come to any agreement when you've got a hit record, when the guy who's sweeping the stairs is going to say, hey, wait a minute, I contributed a word, I own 5%, and holds up everything or just causes all kinds of problems. It also will make it a whole lot easier when it comes to actually doing the copyright and when it comes to registering your songs with performance rights organizations. And so I don't want to interrupt you any more than that or derail what you're saying, but that document, the one that I use, will be available on the website later. and I encourage anybody to use it. Give it away, modify it as it suits you, but write it down and sign it. You'll never regret doing that.
Way better than a fist fight later on. So.
Yes, or a lawsuit.
That's
Or a
at least,
lawsuit, right? We're lawyers. Yes.
thanks for that, Michael. No, that was perfect timing. Rod, do you have anything to add?
No, just, I mean, history tells us in so many, with so many bands and so many, so many mixed pieces of music, that there have been huge fights, and the doorman has gotten into them, and the artists themselves, well, we only put his name on it to begin with out of pity, and Michael's absolutely right. By the time something gets to court, reality can be seriously warped.
Yeah.
One other thing, Talia, you mentioned the poor man's copyright, and I when I have copyrighted my music, it's been very affordable, and I think that people should know that the copywriting is not really a very expensive proposition. Is that still the case? It's been a while since I've copyrighted any songs.
Yeah, it's one of the cheaper, it's definitely a lot cheaper than, registering your trademark. So, and, especially if you're doing it quarterly, and let's say that even if you're a prolific songwriter, you can, and we'll get into the registration details, but it's very affordable. It's very possible and easy and accessible.
Even a musician can afford it.
I would think so. And we'll get into another option, which is at least putting the Library of Congress on notice of your works if you're not wanting to go through the registration process. It's really helpful to think of a copyright as a bundle of 6 exclusive rights. So you have your bundle of sticks, and each one of these is a separate stick that you can assign or license. First, the right to reproduce or copy. And then we have the right to publicly display, which is the right to display a work publicly. So a good example of this can be when someone purchases a work of art. They have, along with that work of art, they have the right to display that work publicly, but they don't get the right to reproduce or copy that work when they purchase a work of art. That right stays with the artist. Then we have a right to distribution, to distribute copies of phonorecords to the public by sale or other transfer. A public performance right to perform the work publicly. I'll talk about that a little bit more as we move forward. A digital transmission right to perform the work publicly by digital audio transmission. And the right to create derivative works. So to create a derivative work and to decide who can create a new work based on your original creation. Let's say you're using a sample, a significant sample of somebody's work that may, in incorporating it into your work, that may actually constitute a derivative instead of an original work.
Talia, do Weird Al Yankovic's parodies fall into the derivative realm?
So yeah, that's a good question, because I didn't actually include fair use in my in my presentation, because it's its own subject. It needs its own subject, and I don't want to divert from this. But yes, the fair use exceptions in music are so narrow that I feel like it's almost not worth talking about in this, but I would say that would qualify as an original work because of the fair use exception. What do you think, Michael?
I'm always terrified when my clients ask me for a yes or no on fair use, because it's, it depends on who you ask, right? There's four categories of it, and reasonable minds can disagree, and there's a lot of unreasonable minds out there to factor in also. I believe that Weird Al got permission for the covers that he's put out, and the adaptations that he's done. But what I wonder about is whether, the extent to which they're copyrightable, his original contributions to them.
One of my bands did a punk version of Sesame Street. And I actually called the Sesame Street people, and they said you can do it, no problem. And they didn't want mechanical royalties or anything. So,
well, that's nice.
Yeah.
If you get a call like that, just follow up with an email. This is to confirm that you just gave me permission to use this song.
This was way before email.
That's how you know we're lawyers. Yeah.
Just write a letter. There's 2 copyrights in every song, and a recorded song. So you have one for the composition and another for the sound recording. The musical composition consists of music and including the lyrics, and the sound recording or master results from the fixation of that music or other sounds. One of the rights that I discussed in that bundle of rights that you have in every copyright is the right of reproduction. Just talking about this briefly to kind of prep for future conversations about performance right organizations. There are 2 main sources of income from songs, and that's the mechanical royalty and the public performance royalty. The mechanical royalty involves a label or a cover song. You have these physically reproduced songs that a songwriter earns a mechanical from, and that is a compulsory license at 9.1 cents for each reproduction. And it's compulsory because once the song is recorded and released to the public, anyone can record it. You do have to request a license for it, but they can't stop you from receiving that license in most instances. Michael, do you have anything to add to that?
No, I mean that I think that sums it up. It's been muddied, by the now predominance of digital, for which and streaming, for which the mechanicals are a different animal completely. And there's new legislation on that. But again, that would be its own subject. But it gets complicated. But in the simple old days when people bought records, that was how composers made their living quite often. When an artist sold 1 million records, you had a song on that record at 9.1 cents per song. That was very good money. Nowadays, it's changed, and it's harder. You better be selling T-shirts.
And then the other way is covering songs, and you want to go through. So the artist and licensee doing the covers, they do own the resulting sound recording, but you have to get a mechanical license within 30 days of distribution and pay the royalties. And that is triggered by filing a notice of intention to obtain a compulsory license. And you can go to Harry Fox Agency to request that.
Do you mind if I add something on that subject?
Yes,
when you're releasing records now digitally that contain covers, companies like DistroKid, for example, they will go out and get the mechanical for you. So you just give them all the information when you submit the record, and they sort it out. I recently re-released an old record of mine that had an AC/DC song on it. And in past days, I would have had to get a hold of them. They didn't let Harry Fox administer their publishing. And so it was harder, but now it's easy.
I think that's a really good point, to get an administrative publisher, whether it's DistroKid or CD Baby Pro.
Yeah.
There's a bunch out there. Actually, while we're doing this, it's Ari. Let's see, he has a great breakdown. Ari's Take Academy. I can also share that in the final PDF that I have of the presentation, but he has some great breakdowns of all of the different administrative publishers. So I really like perusing his site for that.
That would be immensely helpful.
Yeah, it's aristake.com. That's what it is, because that's his blog, and it's ARIS take.com. Gary wanted me to include the question of sampling, and this is a quote, get a license or do not sample. And That's become pretty clear case law. So then we ask, well, what about DJ? They're always sampling other people's music. Well, when a DJ plays live at a venue and mixes a collection of tracks, the venue usually pays a blanket licensing fee for the songs that the DJ plays. Technically, if you're playing original music out, then, the venue doesn't technically need that license, but most venues have that license, and the pros are pretty good at hunting them down if they don't. But the issue comes in, so that's what DJs usually rely on, is the venue's license. And also, it's not fixed, right? Because unless somebody is, recording video or recording audio, there's no fixation about what the DJ is doing. So if the DJ ended up wanting to record what they were doing for a night and then, make money off of that, let's say visual audio recording, they might run into a lot more issues with that. Michael?
I think that's why we don't see more records from DJs that have their mashups on them. They get famous for the events, and the events do huge business in non-pandemic times, but they can't release records of their mixes because it would be too expensive, and it would be a nightmare to try to get all the licenses.
Well, there are albums by turntablists, but I bet you they've got lawyers working behind the scene on every single track on that. So,
well, if they don't, then they're just cease and desists waiting to happen in lawsuits.
And also, Michael, you're going to talk, I presume, a bit about how people get paid from those types of when other people play their music. So
yes, yeah.
Okay, so we'll get to that.
Rod, did you have anything that you wanted to add?
No, I mean, I think later on we'll be talking about a cease and desist letter too. So that's something. I'm just trying to remember. I think it was Joe Sample did a jazz album called Sample This, and I could never take if it was an invitation or a threat.
That'd be an interesting legal issue if it came up in front of you.
It would have been.
He told me to sample it, Your Honor.
That was it. Here's the album cover.
There's the license right in the title, right?
It's like, steal this book.
Yeah. Well, Abby Hoffman meant it. Yeah.
He did.
So I know that this is another slide for conversation, but back in 2013, Robin Thicke and Pharrell Williams had a hit called Blurred Lines, which triggered a suit by the family of Marvin Gaye. And they actually prevailed in court. The jury ruled that it was infringement and that this song by Thicke and Williams infringed on Marvin Gaye's 1977 hit, Got to Give It Up. The only thing that was the jury was able to review, they could not listen to the sound recording in court. It was only the sheet music. And they decided the entire case based on the song's lead sheet, which was on deposit at the Copyright Office, and the extent to which the sound recording could permissibly inform the substantial similarity inquiry, but it was really focused on the sheet music. And there was a lot of conversations about how this could lead to a chilling effect for creativity in general, because of how much the melody and harmony and rhythm differed in the two songs. Gentlemen, what are some of your opinions on this case?
Was the jury really forbidden to listen to the actual recordings?
I think it was very limited. It was very limited, and then they couldn't make their determination based on the sound recording because that's not what was with, on deposit.
When I heard about the case, I called up both recordings as I do, and I listened to them, and I thought the lawsuit was absurd, and I thought there would not only be a chilling effect from it, but I thought if that decision stands, then somebody's going to claim they own a 145 and sue all the blues players, because I thought it really was more about the style of it, but. If they really were able to focus on the lead sheet and it was that similar, then maybe there's something there. But it was really, to my ears, it was a feel thing. and even the lead sheet on a lot of blues songs would be the same. And so I think that decision got it wrong, but that's just my opinion on it.
The recent lawsuit between Spirit and Led Zeppelin over Stairway to Heaven also did not allow the jury to listen to the music in that trial.
What is the rationale for that? I can't imagine why listening to the music wouldn't be absolutely inherent in understanding if the songs were similar.
I can say from experience that judges have an abhorrence of the subjective, and how one perceives art can be so subjective that a judge could easily not trust it. I don't recall reading the specific grounds for the ruling, and I'll say I'm probably wrong. But
these older cases, only the lead sheets or the composition was filed, and not the sound recordings, right? So that's part of it.
Yeah, Marvin Gaye would not have probably been able to upload a file the way you can now, a sound file the way you can now.
And Marvin Gaye would not have sued this case. He would have said, "Cool, that sounds like me."
Right.
It's always the estates. Not always, but often.
There's questions as to what the reach and consequence of this case is, given that the jury could only really take into consideration this lead sheet. But there is this issue of trying to copyright musical styles that is of a concern. So we'll just see, so far there hasn't been any litigation that's really a cause for concern based on this case, but we'll see as we move forward. Publishing is the revenue from the song. And we covered it briefly, but it only concerns the composition and not the sound recording. So if you write the song and you own your publishing until you agree otherwise, and a publisher owns or administers the copyright of a work. Again, we were talking about like DistroKid being the administrative publisher. Another question that comes up, and that will come up in your copyright registrations with the Copyright Office, is who you put down as the author or holder of a copyright. So it's initially owned by the author or authors of the original work, except in the case of a work for hire. It's important to talk about work for hire. We could probably have a whole hour just on work for hire issues, but it usually arises in a couple cases where either you're an employee who is creating a work within the scope of your employment, so it's not owned by you, it's owned by your employer, or where two parties enter a written agreement with each other designating that your contribution or your creation is a work for hire. So this would be a great language to have in the case of somebody coming in to the recording studio and contributing some vocals to your song. Any other comments?
So in other words, they get paid for the gig, but they don't get paid in perpetuity from the royalties to the music.
Mm-hmm.
Yeah, this is
what you want when somebody comes in and sings on your record is, ideally, I say ideally because most people never bother getting these agreements. They just shake hands, but it's better to have an agreement with a waiver, a release, and a piece of a paragraph or two that says that the artist for whom you're doing this work is the owner of the entirety of it, regardless of any copyright that may attach to what you've done. And if there is any copyright, then you assign it in perpetuity, whether you give them $1 and make it a work for hire or it's an assignment. It's good to cover that, because otherwise, again, when you're just hanging out in the basement jamming and your record gets released locally and sells 100 copies, there's nothing to fight about. But the
permissions that you need moving forward with these contractors. If somebody is not working for you, they are a contractor. And if they are contributing to your work in any way, you need to think about what they're contributing. And, technically the same with, the engineer. Or let's say you're a graphic designer for your website, and it doesn't have to be a work for hire, but you want to make sure that you have.
I've had numerous artists come to me and say that, the engineer of the studio won't let me have my recordings. They want a percentage now. And that wasn't the deal. They were hired. The artist didn't know they needed to get something in writing that said that they owned it when they paid the agreed amount. And somebody changed their mind about what they were entitled to, and then you got a problem. So it's like all these things, much, much easier managed in advance.
It's best to have an agreement, but even a back and forth email saying, look, I will pay you this, or I'll give you a handful of, digital downloads for, once this whole project is done. And then the other person confirms, that sounds great. That's good. You want to keep those emails, and that's better than nothing.
Agreed. You can prove a contract that way.
Very good. Yes, if it's in writing, that's good.
Yep.
And then this is just what we were talking about, so
Yeah.
I won't repeat myself here. In lieu of a work for hire agreement, you can have an assignment agreement, which requires very specific language that you should either retain an attorney to create for you, or just do a lot of research online.